What happens if you're going 120 miles an hour down the highway, drunk, with a gun in the car? Well, let me tell you about one of my clients that happened to several years ago. He was driving north on Highway 270 in St. Louis County, blows right by a police officer. He's going 120, he doesn't even see the officer's car there. He's so far ahead of the officer by the time the officer flips his lights on that he doesn't see the lights right away. Now, he lived in Maplewood at the time. He was exiting onto eastbound 40 to head home. And just as he's on the exit ramp, he sees the lights and he knows he's cooked. So he goes around the corner and he pulls over, makes the stop voluntarily. The officer is so freaked out, he comes up to the car with his gun drawn, gets out, gun drawn. You're under arrest, throw your keys out the window, I want to see your hands, the whole 9 yards. My client complies completely. He knows he's under arrest now. The officer's told him. He gets out of the car, comes around the back of the car. Cop says, "How much have you had to drink?" And my client admits to having 4 drinks. Well, once I got this case, he ended up being charged with felony DWI because it was his 3rd offense. So that's a felony in the state of Missouri. He also got charged with felony resisting arrest by flight because he created a substantial risk to others because of his speed. And at the time, it was illegal to have a loaded gun in the car if you were intoxicated. That law has since changed in Missouri, but he was also charged with felony unlawful use of a weapon in this case. So 3 felony charges. When I look at the case, I get the video, and I see the way the officer handled things right off the bat. Well, let's talk about the statement about 4 beers. Well, he was under arrest. He's in custody. He wasn't Mirandized. The officer asked him the question. It wasn't a voluntary statement. Violation of Miranda. That 4 beer statement's getting thrown out in court. No questions asked. Then we come to the next step, which is, what did the officer actually know at the time that he placed my client under arrest? He still didn't know how many people were in the car. He didn't know if my client was drunk at all because he hadn't even observed my client yet. He was lacking probable cause for a lot of reasons about what happened. He also didn't know that my client was resisting or trying to flee him. He just knows that he was going 120 miles an hour. And you know what? It takes a minute to slow down when you're going that fast. So I brought all these things up in a motion to suppress in court. I filed the motion to suppress. Prior to the hearing, the prosecutor and I batted around a lot of these different things about what should happen with this case. As we do, these negotiations tend to continue after the motion to suppress is filed. So we talked a lot about it. At the end of the day, we reached an agreement, a compromise, but it worked out very well for my client. The DWI was dismissed entirely. The gun charge was dismissed entirely. The resisting arrest was reduced to a misdemeanor, and my client did 6 months of electronic home detention where he was able to go to work and had to stay home otherwise. My client was thrilled with this outcome. No felonies from a really bad situation. And honestly, it's just the officer jumped the gun in this case. There are laws, there are rights, and even though my client was in the wrong in a lot of ways, the investigation wasn't done properly,